number 114153, Hodes and Nauser et al. V. Derek Schmidt et al. It's time I would ask counsel to rise and state your appearances for the record.
May it please the court, for the state defendants, Steve McAllister, and with me at counsel table are Sean Paulson and Sarah Warner, as well as several members of the Attorney General's office here as well, ready for argument.
Very well.
May it please the court, Janet Krebs, representing Kansas physicians Dr. Hodes and Dr. Nauser. Joining me at counsel table are Genevieve Scott and Lee Thompson and several other members of our legal team behind me.
Very well. Do we have any preliminary matters to take up before oral arguments?
No, Your Honor, not for the state defendants.
Right. Very well. Counsel, you may proceed.
Mr. Chief Justice, and may it please the court, with the court's permission, I would like to reserve 10 minutes for rebuttal.
10 minutes is granted.
Thank you. Mr. Chief Justice, and may it please the court, today this court is being asked to do something it has never done before, to recognize a fundamental personal right under the Kansas Constitution, and in particular, the right to an abortion. This court, however, should decline the plaintiff's invitation to judicial activism and instead hold that such a right does not exist under the Kansas Constitution for several reasons. First, the text of the Kansas Constitution does not support recognition of such a right. Second, the history of the Constitution and the history of Kansas does not support the recognition of such a right. Third, the policy preferences of the people of Kansas on this question have been clear since territorial days, and they have been consistent. Kansas law in 1855 prohibited abortion. Kansas law today declares a policy of not recognizing any right to abortion. If the people of Kansas want to create a constitutional right to abortion, they have a ready mechanism for doing so. It's the constitutional amendment process, which Kansans have not been shy about utilizing. In fact, there have been at least 29 amendments approved in the last 40 years since Roe versus Wade was decided. And in fact, that's the very method that the governor of New York recently proposed that New York adopt for recognizing a right to abortion under the New York Constitution.
Counsel, if we adopt your view, does it mean that as far as the Kansas Constitution is concerned, there is no government limitation on reproductive rights in Kansas?
Well, Your Honor, I think there is a couple of things. One, there are other constitutional provisions such as the equal protection notions that might apply depending on, but if you're asking is there a substantive right, all we're asking the court today to do is to say the Constitution does not recognize a right to abortion. We're not necessarily speaking to marital privacy or other things that the court might think about, although I do think the arguments we make here in terms of the text, in particular of the Constitution, could be problems with other possible substantive claims.
Well, don't you claim that sections 1 and 2 really don't have any particular meaning?
No, not at all. They have an equal protection meaning. Okay. They do not have a due process meaning. The phrase due process is never used in either one. They are worded very differently than the 14th Amendment provisions. Both clearly refer to equal rights and equal protection, and this court, we recognize, has said Section 1 is the equal protection clause when we're talking about personal and property rights. Section 2 is the equal protection clause when we're talking about political privileges. And I acknowledge that the court for some time has occasionally said Sections 1 and 2 are basically the equivalent of the 14th Amendment equal protection and due process clauses, but the court has never explained why that's so. And looking at the language, it is hard to say they are the equivalent of the due process clause. I certainly recognize they have equal protection components.
Let me give you a hypothetical that's been bugging me for months, quite honestly. A woman is told that she has to have an abortion in order to save her life. does the Kansas Constitution allow the government to say that she must die?
Well, Your Honor, I will think about that one. I guess one of the issues that I do want to get into with the court is if Section 1 has substantive meaning beyond an equal protection provision, then it does have phrase life, liberty, and property. The plaintiffs here are focused solely on on liberty, but you're raising the life issue, which also applies.
I think it applies to both. I mean, your ability to continue living in this world may go to both.
Well, you can't.
But
I guess you can't exercise liberty if you're deceased. But the point would be to save your life. But that very same notion, I think, the court needs to address. Does that apply to the unborn? Because it does say life.
What's your view?
My view.
Under my hypothetical, is there any limitation on Kansas government from telling that woman she has to die for the cause?
Well, that's one that would make one uncomfortable, Your Honor. But I don't think you have to go that far in order to resolve this case.
Does that make the answer no?
Pardon?
Does that make the answer no?
That could Kansas do that? Well,
That yes, Kansas could do that. I mean, the way the question was phrased, I think the uncomfortable answer you're trying not to give is no. There's no.
although,
limitation.
Your Honor, there might be, I hadn't thought about that in terms of, to be totally sure, I'd want to review everything in the Constitution, and there might be arguments for other provisions that would stop such a
The
thing.
reason it comes up is because you've got headers in your brief that says no right to abortion. Okay? Does this woman have a right to an abortion if it saves her life?
Well, Your Honor, I guess what you could do is this would be another position for the state defendants. If, in fact, you decide to recognize some right, that doesn't mean it necessarily is strict scrutiny or an undue burden standard. In the cases this court has actually talked about due process, and they are very few, it has applied a rational basis standard and has never recognized a right. But if in that circumstance it made the court so uncomfortable, you said there should be a due process right, it's rational basis review, it seems to me that proposition would not be deemed rational.
Well, you've asked us to put our heads in the same frame of mind as a bunch of white men in 1859. And if I look at the territorial law that you cite, it provided an exception for abortion to save a woman's life. It seems to me like Section 1 and 2 could have a constitutional protection. So it's not just no right at all. There's once liberty or life gets its foot in the door to the Constitution, then we've got to define the contours.
Correct, and what I'm suggesting is you could, if the court were to do that, though the standard ought to be essentially rational basis, and it seems rational that you would make exceptions for those kinds of situations.
But the state's position is that there's no right whatsoever.
There's, Your Honor, in all honesty, the question is where does the due process sort of notion come from in the Kansas Constitution? And certainly we have argued the language of 1 and 2 just are not the equivalent in that sense to the 14th Amendment due process clause. Now, the other thing to remember, of course, is the plaintiffs have a readily available set of federal rights here that they have chosen not to invoke. I'm not suggesting this court can avoid deciding the state issue. It must, because that's what the plaintiffs have presented. But if the court's conclusion were there is no right, or it is a right subject only to rational basis review, as a practical matter, it has no effect on these plaintiffs because they can bring federal claims and challenge this law under the federal standard, which they claim they can easily satisfy.
But you would agree that Kansas constitutional law can be broader. Their rights under the Kansas Constitution can be broader, as
Of course,
Atchison
of course.
pointed out.
Of course. Yeah, I mean, there's nothing that says this court must interpret the Kansas Constitution exactly like the federal Constitution. That goes both directions.
It can't be, but it can't be less. We
Oh,
can't.
yes, it can be less, Your Honor. It just can't be enforced. So Kansas does not have to recognize a right to various things, but it can't give effect to that. as long as there's a federal floor that acknowledges
Well, we can't
it.
interpret the Kansas Constitution to provide our citizens less rights than the federal government gives, can we?
Yes, you can. You just can't give it effect because federal law preempts the state law. They have a federal right.
But don't we have a rule of construction that we can't construe something unconstitutionally? I mean, isn't that what we do? We strive to avoid unconstitutionality when we construe something.
Well, I thought they were two independent legal systems, and the fact that state law doesn't protect something doesn't take away any federal rights the plaintiffs have. I simply don't understand the point, Your Honor, that you couldn't construe the state constitution to have less protection. This court has often said we construe them equally. That's one option. Several state Supreme Courts do that. But Michigan, for example, said no right to abortion under the Michigan Constitution. There's nothing improper.
You can have the theory, you just can't apply it. That's your point.
Right, and so if you have states that pass a constitutional amendment that says life begins at conception, that's not unlawful as a matter of state law. It may not be enforceable in light of federal law, but the state can certainly express that position on that issue.
I have another question for you, counsel, and this goes back to even more basic or brass tacks than my colleague at the end of the bench. Does Section 1 apply to women?
This court has said it has, and I would think, Your Honor, that
Is that right?
well, it depends on, I suppose, if you take men to mean simply as a gender notion, or if it's more in the nature of person.
What did it mean at the time? It was
At the
drafted
time,
and
it
ratified.
probably, well.
I mean, I'm just
Passed
asking you
by
if
all
you're-
men.
It's passed by all men.
If your answer is that it does, then my natural next question is, how come? And why is that right?
Well, I'm not here to argue that women have no rights, and I don't think we've taken that position under sections 1 and 2. We're
No,
talking about the nature
but
of
you
the
do
rights.
have a heavy thread of originalism in your
Well,
beliefs and your
we're
general
following this
position.
this court says, look at the text, look at the history, and so we're applying the analysis this court has utilized over and over again.
And the text and the history, in your view, point to no right to abortion. Would they not also point to no rights for women, period, under Section 1?
Well, they might, except Kansas has changed some of that, and you also have equal protection
And
provisions.
how have we changed that?
Well, for example, Kansas has acknowledged the right for women to vote, and has long had recognized property rights for women. Even going back to 1859, women could serve on school boards.
The
Justice Brewer has
Constitution
a
has some particular rights that it recognizes for women, but I'm talking about Section 1.
well, I mean, Section 1 itself, that's the text, all men, but that I think reasonably can be construed as all persons in light of subsequent developments. But that, I go back to the notion, we're not saying this is completely controlled by what a group of 52 or so white men decided in 1859. I mean, it's further buttressed by the fact that in none of, and I've looked at them all, I think, in none of this court's cases has it ever explained why Section 1 and Section 2 are the equivalent of 14th Amendment due process and equal protection. It started saying it in 1917. It has never said why that is so, other than it's convenient, I suppose. But what I'm suggesting is the court has said Section 1 and Section 2 are equal protection provisions, and that seems pretty apparent looking at the language. What is less clear is-
Counsel, equal protection, excuse me, my voice is a little crackly here, but equal protection for what?
well, equal protection for other rights that are identified in the Constitution, and equal
So it's,
protection.
in your view, these are procedural only.
Well,
In
that's
other
the
words,
nature-
whatever other rights are enumerated or whatever the legislature deems fit to pass, it has to apply equally.
That's the nature of equal protection.
And that goes right to my question that it seems at least Section 1 has some substantive meaning. Is
Well-
the state's position that it has no substantive meaning whatsoever?
Well, I guess, I mean, the first question is it's not the equivalent of the substantive due process federal notion necessarily. If the court wants to give it meaning,
Well,
It has the power to do so.
I'm not asking whether we should give it meaning. I'm asking whether it has meaning.
To be honest, Your Honor, it's very hard to tell from the original debates if it was intended to have meaning, and if so, what. Because those debates were really about, they started out with the identical Section 1 to the Ohio Constitution, which among other things had language about the right of all men to control their persons. There was a lot of objection to that, and there were two reasons for the objections and why that language disappears. Is because one, there were abolitionists who wanted to make sure they had a way to resist enforcement of the federal fugitive slave law. That was one concern. The other concern, I'm going to get raspy too here, the other concern was more basic in some ways, or at least more general, which was that they were worried they couldn't even enforce criminal laws against people if you had this broad statement that everyone has the right to control of their person. So the debate went back and forth for a while, and then future Chief Justice Kingman said, well, hey, everybody knows the language of the Declaration of Independence. I like familiar language. Why don't we use this language? But he never really explains what that was supposed to do.
If we look at what that kind of language was understood to mean at the time, isn't there a pretty robust history of substantive rights that were attached to that kind of language? And it's in the history of both our federal courts and our state courts, going all the way back to the founding of our country.
Well, there's a robust history of the notion of natural rights. Although even if you go back to Blackstone and Locke and others, they talk about those rights are not absolute. They can be regulated by government for the benefit of all. And in fact, Blackstone talks at some length about the rights of the unborn. And so if you really want to get into the text, it seems to me the court needs to take account of all those words, life, liberty, and property. You can't just take out liberty and say, well, all that matters is someone asserting a liberty interest. If there's someone else who may be asserting a
I
life
definitely agree that if we conclude that this has some substantive meaning, that there's a lot of work left to be done. In other words, we have to decide what rights are we talking about. I was really asking the threshold question, which is it substantive at all?
Well, I mean, Your Honor, certainly the notion of were there natural rights that they would have recognized, yes. But none of them were absolute. And in fact, there was a lot of discussion about even having the word inalienable.
But that, I think you've answered my question. Yes, it is substantive.
Potentially, yes. Although, again, I would say the language itself seems to have an equal protection focus.
And doesn't the federal jurisprudence on the 14th Amendment, when it's talking about personal rights, contraceptive, that kind of thing, refer to them as liberty interests?
They do, generally, Your Honor.
And so the use of the word liberty in Section 1 of the Kansas Constitution means something different than the liberty interest in the 14th Amendment?
I wouldn't be surprised. It predated the 14th Amendment, which didn't exist until 9 years after this was done. So this certainly was not modeled on the 14th Amendment.
No, I understand that, but I'm talking about what does the word liberty mean? Why does the word liberty in our Constitution mean different than something different than the liberty interest that emanates from the 14th? Why didn't liberty?
Well, and why isn't religion, and proportionality? I mean, it goes back to your earlier line of inquiry. The state constitution does not have to mirror the federal constitution. States may have different histories and traditions and cultures. The Supreme Court of the United States rules for an entire country, but states can rule under their constitutions on their circumstances and their particular situations.
But as early as 1917, you referenced Wilson earlier, and I know you say that some of this language is hortatory in that decision, but they talk about the liberty interest, and then they turn to the United States Supreme Court definition of what liberty means.
And that's a choice by this court. I don't think it has to. I mean, again, it goes back to Justice Johnson's question. You could give a broader meaning to liberty than the U.S. Supreme Court. You could give a narrow one. It does not have to be equivalent.
But doesn't history tell us that? I mean, you can go back even further. You can go back to 1884, and you see this court interpreting Section 1 as incorporating a liberty type of interest.
Well, I think if you want to go back to 1884 and Justice Brewer, what you see is a justice saying, look, the Bill of Rights as a whole is not just general statements of principle, but then what he does, he's talking about Section 1 at first, but then he says, for example, and he talks about the right to trial by jury. He's not saying Section 1 itself has any precise meaning. And then this court later, in the Shockey case, said, well, yeah, what he meant was these are general guides, some of these provisions. Some are specific enough for courts to enforce, some are not. And this court put Section 1 in the not sufficiently precise to create a rule of decision. So, it's a mixed...
They seem to change that just a short time later.
It's a mixed bag, although...
Shockey seems to kind of be an island, doesn't it?
Well, Shockey in some ways is the most extensive discussion this court has ever engaged in of Section 1. The subsequent cases, starting with Wilson, just say these are basically equivalent to 14th Amendment due process and equal protection without saying why, other than maybe that the court thought was a good idea, but it doesn't say, look at the text, it's essentially the same. Look at the history and the purpose, it's essentially the same. The court never explains, it just starts saying that, with all honesty. And then it repeats it occasionally as it comes up in cases, but in all but maybe 2 or 3 of the subsequent cases, all that was at issue was equal protection claims. So it's actually been a very small handful of cases that this court has even contemplated the notion of a due process interest under
What
Section 1.
distinguishes equal protection under Section 1 from due process? I mean, you seem to concede that there is some equal protection under life, liberty, and the pursuit of happiness, and not due process. Why equal protection and not due process?
Well, because to the extent the court has given Section 1 meaning, it has been as an equal protection provision. So there are cases, I think Farley, and I'll think of the other one, the Limon, where the court has said, well, Section 1 is the equal protection provision for personal and property rights. Section 2 is the equal protection provision for political privilege. So this court, I'm using this court's description of what those sections do. And I guess as a sort of alternative position, if the court is convinced there is a due process right in Section 1, even that conclusion would not mean it has to be the same as federal law. And in fact, if you look at this court's cases, the very few that even talk about Section 1 or suggest it might be a due process limitation have never applied anything more than rational basis review. And in fact, I can say further, have never recognized any substantive right under Section 1. That I can say with confidence. I cannot say the court has never mentioned or raised due process, but the court has never recognized a substantive right under Section 1.
Counsel, I have a question going back to one of the original points that you started your presentation with, and that was we have to look at the text of the Constitution. And we've talked a lot about Section 1 and Section 2, and I'd just like to recite Section 2. All political power is inherent in the people, and all free governments are founded on their authority and are instituted for their equal protection and benefit, the people. Section 1, however, says all men are possessed of equal and inalienable natural rights. Can you tell us why our founders in 1859 just talked about men in Section 1 and people in Section 2, if we're going to talk about text?
If we're going to talk about text, no, Your Honor. I've read those convention debates more than once for various reasons, and there's a fair amount of discussion, 12 pages or so on Section 1. There's virtually nothing on Section 2. I mean, they basically get done with their big argument over Section 1. They say, what's next? Section 2. It's not much to say about it. They vote, it's passed. So I cannot say from that why they did that.
We have case law that indicates that we believe that the founders or the writers of the Constitution were deliberate in their choice of words. So I'll ask again, what do we make of the fact, if we apply that belief, that they apparently deliberately chose to say people in Section 2, which would incorporate women. In Section 1, they just talked about men, which would exclude women. What do you make of that, if anything?
I'm more inclined to think that may be a historical accident, a combination of Section 1 being Samuel Kingman saying, let's just use the language from the Declaration, which says all men are created equal, doesn't say all people. And Section 2 was taken from the Ohio Constitution, which said people. There's certainly nothing to suggest they really thought about the difference. I understand your point that language should be carefully chosen, but
So if they didn't really think about it, how are we to look at that and say what their intent was?
well, I think the question, Your Honor, is in this case, maybe not for all purposes, but was there any intent or notion that they would recognize an abortion type right? And I think the most you could say is Justice Biles' point that there were territorial laws that made some exceptions to allow abortion, but they certainly, it just seems inconceivable that they would have been thinking about creating rights like that. So and again, we're using this court's own cases that say, look at the text and the history of the provision. I mean, we've been through this in school finance. We don't look back to 1859. We look to the amended Article 6 in 1966 and what was going on and what did the people intend. So, that's why we're arguing about this.
Should we be trying to divine intent, or should we limit ourselves to what people would have understood that these words meant at the time?
Well, Your Honor, I think you could do the latter. I mean, in particular because the former is often hard to ascertain. So in some ways, it probably makes it's a more sensible inquiry, or at least a potentially easier or more productive inquiry to ask how would this have been understood, not what did these 52 people.
There are at least indications, evidentiary indications in historical texts that would give us clues as to what people thought these words meant. Whereas
Yes.
with respect to intent, it's
Right,
a blank slate.
and also just the historical context. So I would, emphasize we're not just talking about history in terms of 1859, but all the subsequent history for over 150 years. Kansas, as a state, has consistently and continuously had a policy position when it comes to abortion, and that's to this day. So in terms of the context, the people of Kansas, if we want to talk about their will, has never been or never thought that there was such a right created under Section 1.
I'd like to talk about that, and particularly your reliance on, really, I guess all the way back, but the statutes that were in existence at the time of ratification. Does the fact of ratification automatically declare somehow that those statutes were constitutional as of ratification? I mean, aren't there, I think you can agree with me on this, Mr. McAllister, at any given moment in our state's history, there are a bunch of statutes on the books that have never been challenged as unconstitutional. The fact that they coexist with a constitutional provision they may run afoul of does not mean they are somehow automatically constitutional.
No, and
does
I'm
it?
not suggesting that, but that they provide context, kind of going to Justice Steagall's question of at least what people more generally understood at the time this was adopted.
Okay,
But certainly,
it's
I
at
mean,
least possible, or theoretically possible, that
It's
at
more
the time
than-
the Constitution was ratified, those provisions would not have passed muster had they been challenged.
or at some point along the way would not have passed muster. I
Right,
mean,
at any
Kansas had a
point.
number of
At
racial
that point.
discrimination statutes and things that we certainly today would say are
At
unconstitutional.
that point
so-
or at any point thereafter.
Right.
And the fact is, those laws just have not been challenged and come before this court so that we could decide this question.
Well, maybe not in recent years, but prior to Roe and the recognition of a federal right, I think we cite some of these cases. There were prosecutions for violating these laws, and those convictions were upheld. So they were actually
Were the
invoked.
laws attacked as unconstitutional?
That I can't remember, but certainly
That's the question. Were they attacked
I
as
would be
unconstitutional?
surprised if a defense attorney didn't argue. But I can't remember. I'd have to look at those cases. But I think we cite those cases where there were prosecutions between 1859 and 1973.
But just the fact of prosecution, the whole, you have the statutes involving a quick child, but then you have just earlier abortions, and they're misdemeanors. And the earliest case that on the prosecution, it ended up being a $50 fine. So, the state's interest doesn't seem to be as strong as you would need it to be. I mean, I keep getting back to, are we saying that the Kansas government would not be limited if it wanted to force a woman to give birth to the child that when she was a victim of rape or incest? Is that really your position?
Well, that's where I think, Your Honor, we've had this discussion before, and you, of course, are pressing me, but if the court were to recognize a due process interest, it doesn't mean it would have to be subject to strict scrutiny or even an undue burden standard. And if you use the rational
I'm still
basis...
just trying to get my foot in the door, because you wrote your argument not wanting to open the door. And as we've had our discussion here, I feel like there's a crack here. And, you know, and it's when you start thinking of these examples, I mean, are we really saying the government's not limited if it wants to sterilize mentally ill people? I mean, these are the interests that come under Section 1, and at some point we have to say, well, yeah, there's got to be something substantive here. So now, once we're there, we got to work through the contours of the law, and that's all I'm trying to get at. But it seems to me that you really are allowing for the possibility that Section 1 does provide a woman some reproductive right. Now we just have to figure out how that plays out.
Well, yes, I guess we argued it, door is shut. And if I'm going to lose door is shut, then I'd like to keep it.
Should you win, door is shut, under this language of the Constitution?
Under this,
As we've explained, I mean, is that the answer, that the door is shut? Because we know what it means if the door is shut. So is that what you're saying it means?
well, Your Honor, I realize that's a troubling, perhaps, conclusion. And I guess I'd say, you know, it doesn't necessarily take account of what I hope are the democratic process, political realities. It also doesn't take account of the fact that the federal law protects these rights as well. So in some sense, if Kansas were to take that position, it's just an expression of a preference, but it's unenforceable because federal law provides those rights to people.
What makes
go
the
ahead.
difference between preference and policy? I mean, you've been relying on expressions of preference
Well,
via
I
statutes
mean,
and
I was just saying,
prosecutions to make policy or to support the existence of policy.
so then, well, excuse me, what I'm trying to say is that Kansans consistently, through statutes, have expressed a policy preference on this question, that a general preference that there be no right to abortion recognized. Now, Kansas law has never said, to my knowledge, under all circumstances is abortion prohibited. But it has said, basically, the preference of the people is there not be a constitutional right to abortion recognized. I mean,
You think
there's...
that's implicit in what you've described? I'm sorry, I think.
Well,
I
it's
have
explicit
interrupted my
in
client.
statutes. There are at least 3 statutes that say.
You said constitutional right, and the statutes can't tell us what the
No,
Constitution
no, no,
says
no, no, no.
directly.
But I guess I'm suggesting that in terms of protecting rights here, the Constitution isn't the only thing that exists.
Right.
Statutes also are out there. Federal law is also out there. And at this time, those things do provide protection, even if the Kansas Constitution did not.
I want to
That's what I'm
defer to
trying
my
to say.
colleague. I think I
You-
might have interrupted him.
You made a
Sorry.
reference to Ohio, and I went there too because we know that provisions of our Constitution did come from Ohio. Although I recognize the difference between Section 1, just so you know, I recognize the difference between Section 1 in Kansas and Section 1 in Ohio. That said, Ohio found a state constitutional right, reproductive right, didn't it?
It did, yes.
And when it faced the point that you're making about, well, there's this federal right over here, so we ought not to mess around with the state constitution, the Ohio court said, you know, our federal system of government is that we have a federal government, we have state governments, and state governments do produce constitutions, and it's our job to make them substantive. And so then it went about the business of finding reproductive rights within the Constitution and then defining them. My question to you is, do you have are you familiar with the Ohio decision? And if so, do you have criticisms of the analytical process that it went through?
Well, certainly not as a general matter. The state constitution certainly can be different than the federal constitution, and I do think it's incumbent upon the court, this court for Kansas, the Ohio Supreme Court for Ohio, to look at the state constitution and interpret it. This would just be me personally, independently. Federal law may be persuasive, it may be relevant, but it's this court's obligation to decide what Kansas law means for Kansas. So I certainly have no argument with that. The only question would be then, are there sufficient differences between the text and history of our Section 1 as opposed to the Ohio Section 1 that might lead to a different conclusion than the Ohio Supreme Court reached? But again, the state constitution does not have to provide at least as much protection as the federal constitution. It simply does not. I mean, a state could choose not to recognize some right that's in the Federal Bill of Rights, say we don't recognize that. It doesn't matter. As long as the federal right is there, the person is protected and has that right, and that's certainly true of the plaintiffs in this case.
Mr. McAllister, I have a couple of questions that just move us down the line and get back to maybe a little more esoteric rather than concrete questions. If you would just assume with me for the purposes of argument that we are going to say that there is some sort of right and that it's protected in fact by strict scrutiny review rather than your preferred rational basis. I want to talk about compelling interest and narrowly tailored, because I don't really see those arguments, and perhaps it's because you just don't want us to look that direction. But could you talk to me about that? You've described the interest of the state as important, profound, legitimate, but I don't think you've described it as compelling. And I want to understand the differences between those terms. I think federal law tells us there is a difference between them, that there's even a hierarchy between them. So
There is.
if you could describe that for me, I'd appreciate it.
Well, so yes, under strict scrutiny, under federal law, it's a compelling interest, narrowly tailored or least restrictive means. Intermediate is important or substantial interest, substantially further than the rational basis. There's a reason, and the law might further that reason. Well, I think part of the reason we haven't argued about it is because no one, except maybe in this court, have the plaintiffs started arguing about it. In the lower courts, they were talking about undue burden. And
Wasn't it where Judge Atchison ended up in the Court of Appeals?
I think so.
I think so,
I mean, to be
too,
honest, reading
based on
that
the-
opinion, I think what he was suggesting is it's different than the federal rights, certainly.
Yes, I
And
mean,
my
he's
sense
not
was
talking
that-
about substantive due process, he's talking about personal autonomy or
And
self-determination.
that he wanted a higher standard than undue burden. That I agree with. Exactly what he intended, I'm not quite so sure. But
Okay,
if you
well,
want to
let's
talk,
just assume that's what he meant. Neither one of us may be totally certain on that, but let's just assume that's what he was driving at, so that, I wanted to understand your argument on that.
so then the question would be, well, that would have to be evaluated, and in our view, probably could not be at this stage. I mean, if this court let me put it this way: if this court recognizes that there is a right, and has a standard of undue burden or strict scrutiny, then this probably needs to go back to the district court, and we can go towards an evidentiary hearing and decide whether there's a permanent injunction or not here. I mean, the way this played out, there's very little evidence on a lot of the points, but let me describe some governmental interests here, and we may or may not agree on where they fall in the hierarchy. Certainly if you look to federal law, the U.S. Supreme Court has said in the abortion context that the interest of protecting the ethics of the medical profession is an important governmental interest. That's the Gonzalez case. It has also repeatedly recognized the state's interest in basically acknowledging and supporting the dignity of human life. Of course, patient safety could be an interest. We haven't had a chance to develop evidence really on that point here. And of course, protecting the potential for human life, which is why the rules change post-viability. So there's at least 4 interests out there,
Is this fourth one really different from the second? They sound the same to me.
which I can't
Potential
remember.
and human life, I mean, it's all the same, isn't it?
Well,
I
I
mean,
think
the way that you described your interest, I think, up to this point is promoting human dignity and respect for life, including life of the unborn.
Right.
That's all one interest, really?
I don't think so, Your Honor. I think
Okay.
that one could start at a much earlier point in the pregnancy, whereas the protecting the potential for human life, the court has said does come into play, but really becomes predominant at the point of viability.
Okay.
Whereas I think the dignity point would be throughout.
Okay, I understand the difference now, thanks. So I understand the formulation that you would give the state interest. Now, where does it fall on
So
that hierarchy?
if any of those are compelling interests, and we can argue they are, but I cannot say that case law says they are, because the U.S. Supreme Court has not held them to that test. It's always been talking under an undue burden standard, so it doesn't really say these are compelling, but they are important, they are recognized. If we looked at narrow tailoring, though, this this law is described as a ban, but it's not really a ban. It's and like Gonzalez, and then it goes about the method that's used. There are still several ways that these D&E abortions can be performed. And then the question would be, are they narrowly tailored? The state's view would be, yes, they are, to accomplish the objective of the law, because it still provides options for the physicians to perform the abortion.
The evidence as it exists in the record right now is 95%, though, would be prohibited, correct? The methods used in 95% would be prohibited.
Well, the method would be changed. The abortion
be
wouldn't
changed.
be prohibited.
But, I'm sorry.
The abortion would not be prohibited.
No, I understand
the
that.
method
There'd
would
be other
changed.
the method. That's why I said the word method.
Right, and again, trying to put it in context, I think at least 50% of the abortions in Kansas are medication abortions, so they're not even this territory. So
We're talking about second trimester.
second trimester, kind of in the middle area, probably 14, 15 weeks after that point.
Okay. You mentioned a moment ago, I know, I see your time's expired, but I just have one more question I want to give you a chance to talk about before your opponent visits with us. And that is about what happens depending on how we rule on the central issue here. Is there going to be need for additional proceedings in the district court no matter what? It seems like to me there is.
Oh, yes, there is, because there are other claims and things that have not
Other
even been
claims,
touched
exactly.
or addressed yet.
There were claims that the district court never even addressed.
Absolutely, absolutely.
But even if we were to rule, well, really, no matter which way we rule, well, not really. If we were to rule in your opponent's favor on the existence of a right and on the possible infringement of that right, and that's really, we're still in possibility land because we're on preliminary injunction, right?
Exactly.
Okay, we still have ongoing litigation that would have to be pursued in the district court
Correct.
to the extent the parties remain interested in pursuing
Right.
it,
Correct.
on whether in fact
Right.
there is an infringement.
I agree with that 100%, Your Honor. So
Okay.
if you said there is a right, and this is what the evidence is right now, so it shows justifies a preliminary injunction, or at least the district court did not abuse its discretion, then it would go back and
All
we'd be
we're
able.
deciding today is whether the district court abused its discretion in entering the preliminary injunction order,
And
which
basically,
is about possibilities, not
right. And our
actual.
primary argument is the abuse of discretion is getting the fundamental question of law incorrect. And we recognize the evidence is very limited at this point, and we're not trying to convince the court as an evidentiary matter right now that this court succeeds constitutional scrutiny.
Thank you.
I have
I have real quick to tie into your compelling interest. Help me understand the patient safety interest. I'm looking at it from practical aspect. Before Roe v. Wade, you heard all of the. I'm old enough to hear all of the horror stories about non-medical abortions, and it was pretty unsafe for a number of patients before medical doctors could get involved. So explain that aspect of it, plus the aspect of what I'm reading on the alternative methods would favor the fetus, but at a cost of patient safety. You understand what I'm saying
I
there?
understand what you're saying, but I would say first, as a preliminary point, Justice Johnson, the patient safety is one possible interest I was identifying. And it could be an issue in this case, but frankly, we don't have the evidence fully developed, but I can give you a little bit. So with these abortions, there is one method, digoxin injection, that there's some indication that that actually makes it easier to remove the fetus, which could improve patient safety. Again, we haven't had a chance to develop evidence on this. And the most the plaintiffs say about umbilical transection is that it would add a few minutes to the procedure, or that it can't always be done, but they don't say it can never or cannot frequently be done. They just say it can't always be done. And that's all evidence that we would develop, but this came up in a hurry, and they, of course, had the chance to decide to file a lawsuit, so they've got a few declarations from doctors, and we haven't had a chance to really get into that evidence on patient safety, but that is one potential, but it's not the only one. And certainly you can consider all of the interests. And did I leave out a part of your question, or have I? Okay.
I have two, before you sit down, two what might even be more esoteric lines of inquiry. And the first is there any reason, I mean, we're here to interpret and construe our state constitution. And we know our state constitution grants rights. A lot of discussion about whether Section 1 grants rights. But is there any good reason from the text, history, meaning, etc. of our state constitution for us to import the federal system of tiered scrutiny into our state constitution? And the reason I ask that is it appears, and I think this is well fleshed out in the scholarly literature, that tiered scrutiny system was an invention of the 20th century court, and has been criticized often as simply allowing the court to accord favored rights greater scrutiny while allowing less favored rights to pass with the lower level of scrutiny. I'd like your opinion on that.
Certainly, Your Honor. The short answer to your question is there's absolutely no reason this court has to adopt federal standards. Now, the longer question or answer is, are there good reasons to do so? The main one I can think of is efficiency. You have a body of federal law, so you can refer to those federal cases. Often under state constitutions, there's not been a lot of litigation on the state constitution.
But we have an obligation to construe our state constitution.
I absolutely agree with that.
Is it consistent with that obligation just to say, well, we're going to take a shortcut? Is that consistent with that obligation?
Well, I'm not sure I want to critique the court on that question, but I would say this, that is what has more or less happened in this context, where the court, as I've been saying, since 1917 has simply said it's the same as the federal constitution. I would think it would be wonderful if the court would explain how it gets to either that conclusion or to an independent version. And equal protection and due process, those are definitely, in some sense, very indeterminate phrases and notions. So it's not self-evident that equal protection has to result in 3 tiers of scrutiny. And there are Supreme Court justices over time who've continued to argue that's not really how we should do this. So I certainly think your point is well taken, that there are potentially many other ways the court could approach equal protection.
My second question really has to do with what's our role in this, structurally speaking. And you haven't brought this up, but it's argued thoroughly in the briefs and in the lower court about the presumptions that attach. And you've argued for a presumption of constitutionality. And we know in our case law, that's often recited. It's phrased differently in different cases. Sometimes it's all doubts have to be resolved in favor of constitutionality. Sometimes it's can't find something unconstitutional unless it's clear beyond a reasonable doubt. You've got these various formulations. And I guess my question is the same. We're construing our state constitution. Is there any reason to think from the text and history of our Constitution that presumption is right?
Well, again, the court has said it for a long time.
I understand that we've said it. I guess
I think the notion certainly comes out of separation of powers principles, and this court has certainly said the Kansas Constitution embodies separation of powers principles, which I think it does. I mean, we clearly have Articles 1, 2, and 3.
I agree with you on that.
So, that one, I think there may be less reason to see a difference perhaps than federal separation of powers notions, in that our two governments are organized very similarly.
I guess I could see if the presumption of constitutionality is a tiebreaker. In other words, we don't get to weigh in on constitutionality until the other two branches of government have already, at least implicitly, said this is constitutional. So we got 2 out of the 3
Correct.
branches say
Correct.
constitutional. And so maybe if the factors or the considerations are in complete equipoise, we might say, well, there's a presumption, we're going to accord due deference to the other branches in arising out of separation of powers. But that's really not how we phrase the presumption. We phrase the presumption, there's a big thumb on the scale in
Right.
favor of the state. And as I read the framing of our preamble, Bill of Rights, etc., it strikes me that it's a very counter-majoritarian document. There's a great deal of comment about the danger of too much power in the hands of the legislature. There's a danger in too much positive law. I mean, you've read it too. It's all in there. In fact, the delegates go so far as to praise, for example, the Wisconsin Supreme Court in the Booth cases when they tried to nullify, federal Supreme Court decisions. So there's at least some evidence that they thought the judiciary had an engaged role to play here.
Yes, and I guess I would say about the presumption is I do think it makes sense in that the challenger should be pointing to something specific and convincing the court. I think, does it have to be beyond a reasonable doubt? That seems kind of an odd standard imported from criminal justice notions. So maybe it's a tiebreaker, and maybe it's at least a starting point of who bears the burden to come forward. That every time somebody says a law is constitutional, it's not the state's obligation to prove it is. I mean, the challenger has to make some showing to put it in question. That's another way I would think about that.
Thank you.
How, we're on the presumption, and you claim in your third issue that the district court misapplied or didn't apply the appropriate presumption of constitutionality. Given that, but how did it impact? I'm not seeing where you actually contradicted the findings of fact in what you submitted. Even if it did, how did it impact the district court's findings of fact? I don't see where it did.
Well, I think, Your Honor, the way we see that is the district court said, well, I find there's a fundamental right here that throws everything basically in the state's favor out the window. There's no presumption. The plaintiffs have given me these declarations, and I just don't see anything from the state. In fact, he did have what we could produce in a very short amount of time without the chance to do discovery. So we had studies and things, and he gave basically no credence to anything the state put in front of him. And it was more from the state's perspective, the state defendants, we had then taken on the burden to show all of these interests and show how they were furthered, rather than having the plaintiffs, basically nullify all of those. So I mean, he made their proof was, let's say, fairly modest and fairly limited. He didn't really require that much from them because he discounted everything and anything the state
And
had.
it's given the nature of the proceeding, that's how those
That's how
can
the,
work.
I mean, the
Right.
preliminary injunction, yes. I mean, we recognize the nature of the proceedings, so.
Do we have any further questions? Counsel, before you sit down, because this has taken a little longer than what I thought, we wanted to take a 10-minute break in about a minute or so. So I wanted to let you know, because we've been peppering you with questions, if you'd like to take a minute or two to wrap up. I know we'll see you on rebuttal, but you'll have that opportunity now if you so desire.
Okay, I appreciate that, Mr. Chief Justice. So what I would close by saying is a fundamental right to an abortion is not justified by the text or history of the Kansas Constitution. We've talked about that. The court's cases have never recognized a substantive right under Section 1. That I'm quite certain of. But if the court were to decide that there should be some recognition in Section 1 The state would ask that it be a rational basis type standard to deal with the potential, if you will, real outliers such as Justice Biles posed, but not something higher. That would simply be inconsistent with the history and the will of the people of Kansas. And I would remind the court that as a practical matter, these plaintiffs have well-established federal claims that they could raise and they say would easily resolve this case. So if the court gives no or more limited effect to a right to abortion under the Kansas Constitution, these plaintiffs are not without an alternative means to pursue claims here. Thank you very much.
Thank you, counsel.
Mr. Chief Justice, and may it please the court. In this case, we are asking the court to stay the course that it has followed for more than 100 years. This court has long recognized that Sections 1 and 2 of the Kansas Bill of Rights provide enforceable rights and has looked to the federal 14th Amendment to determine the scope of these rights as to both equal protection and due process. Under this framework, the court has remained true to the text of these provisions and ensured that the protection for the civil liberties of Kansas citizens have advanced to reflect the general march of progress. The right to abortion has been protected under the 14th Amendment for more than 40 years. In the Alpha case, this court acknowledged the fundamental right of pregnant women to obtain a lawful abortion under the federal Constitution and noted that it customarily interprets Sections 1 and 2 to echo federal standards. As Alpha indicates, the customary analysis should apply here, and the right to abortion should be recognized under the Kansas Constitution.
So
Counsel,
what in, go ahead.
can we agree that plaintiffs made a strategic decision to bring this case only under the Kansas Constitution, since the federal case law, at least at this point in time, is pretty much a known factor? You made a strategic decision to come to Kansas and look at this Constitution, have us look at this Constitution.
Yes, Your Honor. The physicians decided to exercise their rights to have this court look at the scope of protection under the Kansas Constitution. And as this court noted in the Lawson case, federal constitutional protection seems to ebb and flow with the political tide. And we think that it's important for the citizens of Kansas to understand what their rights are under the Kansas Constitution.
So what in the text of Section 1 moves us past just a general statement of inalienable rights to substantive due process?
First, it's important to remember, as you have just noted, that Section 1 is the first provision in the Bill of Rights. And even though it was modeled on the Declaration of Independence, the fact that it's found in the Bill of Rights in Kansas means that it should be given, it should protect enforceable rights. What moves it beyond the characterization of a glittering generality to an actual protection of concrete interests is the inalienable right to liberty, which the United States Supreme Court has recognized provides concrete protection to central values, including privacy, autonomy,
But counsel,
dignity.
I'm sorry to interrupt, but the United States Supreme Court has recognized that that word, as used in the United States Constitution, has those meanings. I'm not aware. Certainly, it hasn't found that with respect to the word liberty in Section 1 of our Bill of Rights.
Your Honor, what this court has done for 100 years since the Wilson case is say that the due process, that Sections 1 and 2 will reflect the due process.
We've basically said we're coupled. We're coupled with federal jurisprudence as it regards with regard to equal protection and due process.
I think that what the court means by adopting that approach is that the principles and values that the United States Supreme Court has recognized and protected under the 14th Amendment are also principles and values that should be protected under the Kansas Constitution. And so it's not simply looking at what the U.S. Supreme Court has said and adopting it wholesale. I think it reflects a deeper,
Your argument would be then that there's
acceptance.
at least an implied meaning of our earlier case law that this court was actually construing and interpreting the language of Section 1 and was looking to federal case law to inform that analysis.
exactly, and that the liberty, inalienable right to liberty in Section 1, and the liberty which is part of the due process of Section 14, that those two liberties encompass similar values and protect similar rights.
Do you suggest that the founders of our state constitution intended to follow whatever guidelines the United States Supreme Court established and apply it to Kansans? Is that what the founders intended? Because that's what we've done, but is that what the original intent was? Just follow whatever the U.S. Supreme Court does when it comes to equal protection and due process?
I don't think that that the founders could have literally intended that exact path of analysis. I do think, however, that based on the language of the of particularly the inalienable right to liberty language in Section 1 suggests an intent to provide broad protection, and this court has relied on the federal development for the
I mean,
contours of
the
right.
Kansas framers chose different language than it didn't exactly mirror what the United States Constitution did when it came to those rights. Do we take any meaning from that? That it's intended to be interpreted differently?
I don't think you can necessarily compare, because of course at the time that the Kansas Constitution was adopted, the 14th Amendment
Right,
had not
right.
been adopted. But what I do think is fair to draw from the language that was adopted, modeled on the Declaration of Independence, but included in the Bill of Rights, that the framers intended broad protection, and that a helpful analytical tool that this court has recognized is the contours of the right that have been developed under the 14th Amendment.
Isn't there some significant evidence in the historical record that would suggest that the framers of the Kansas Constitution were not very happy with the United States Supreme Court, which had just issued decisions like Dred Scott, had upheld the Fugitive Slave Act? There's a lot in the record that indicates that the framers of the Kansas Constitution were actually acting in opposition to some of the interpretations of the United States Constitution that had been handed down.
And that was probably a dominant sentiment at the time.
And can that inform, and I want to be careful to separate the question out. I'm not asking about what rights are protected in the Kansas Constitution, but specifically, can't that inform our understanding of what you might call judicial federalism, where our state constitution and the framers intended that this court, when looking at our state constitution, do so independently of the United States Supreme Court?
I think there are several pieces to the answer to that question. First, this court does have an independent right to construe the Kansas Constitution. But that understanding of what those rights are has evolved, and this court has recognized in the Lawson case, for example, that the rights need to evolve to recognize changing social conditions and the general march of progress and greater recognition of liberty. And so while the literal intent of the framers is one piece, as is the text of the language itself, this court has also looked to other sources for interpretive guidance, primarily the 14th Amendment, but in many cases it also has looked to what courts in other states have done in looking at their similar provisions. And so I think that it's a piece. I don't think it's conclusive or definitive.
In other words, is it as simple as saying that the meaning of the word liberty in the Declaration of Independence has no different meaning than does the use of the word liberty in the 14th Amendment?
I think it's a little more, there's a little more to it than that, because even at the time of the Declaration of Independence, I believe the framers intended that to be a broad and encompassing concept, but the concrete meaning of it has been developed in the context of specific challenges or restrictions on that right. And so the concept of liberty, I think in both Section 1 and the 14th Amendment, yes, are the same. The meaning of that has evolved over time, if that answers your question.
And that gets to one of the big issues in this case, which is what is the proper interpretive method that we should use? And obviously the parties argue about that, and I think it's fair to say there's some inconsistency perhaps in our case law, or at least we've made different pronouncements about that at different times. My question is, if we choose to apply an interpretive method that limits us to the meaning of the words at the time they were adopted, can you prevail?
I believe that we can prevail. Before explaining that, however, I would point out that to do so would be, in effect, to disavow constitutional protection that this court has at least identified, if not applied, that Sections 1 and 2 would mirror the federal standards. But I do think that the concept of inalienable liberty standing on its own, in light of the entire history of the Constitutional Convention, which I'm certainly not an expert on, but which I think Judge Atchison went through in careful detail and concluded that even though the history is not definitive, the best takeaway from it is that the framers of the Constitution intended to provide broad protection to liberty when they adopted Section 1.
I think even Judge Atchison acknowledged that if we were limited to the original public meaning of the words, that this right would not have been recognized. I mean, he went on to talk about the aspirational hopes of the founders and talked about a lot of the language that you cite, that the meaning has to keep up with modern notions of liberty, et cetera, et cetera. I'm trying to cabin my question on that within the limited range of the original public meaning of the words. Do you have any evidence that would suggest that the original public meaning would have included the rights that you now seek to assert?
Not in that extremely literal interpretation of, does the word abortion or does the word due process appear in the Constitution? And of course, the corollary of the suggestion is that if that's true, then in fact the state may well be correct that there is no substantive due process protection.
So the legal point would just be that it appears to me that you're conceding that for you to prevail, this court has to adopt an interpretive method that allows the meaning of the Constitution to change over time.
Well, I think that is what the court has done. I remain convinced, however, that the word liberty and the inalienable right to liberty can, standing on its own, the text of that can support the rights that we're seeking to have the court recognize.
And wouldn't the very fact that every indication is that the founding fathers in this state were aspirational, wanted things to be better than they were, indicate that they intended the Constitution to be applied within the context of the world as it will be when it's to be considered in the future?
Exactly, Your Honor, and I think that this court has recognized exactly that in the Finney case, where it has recognized that constitutions by their nature express broad protections, but that they are intended to govern not just the existing, meaning the existing conditions at the time, but to also govern future contingencies.
I think you're right that we have said things to that effect. In fact, I'll just read you one of the most expansive statements that I could find, at least in our case. I think you cited as well from the Markham case, where this court said that words have to yield to the pressure of changing social conditions, more enlightened ideals, and the general march of progress. And so if this court were to choose an interpretive method that is consistent with that, I guess my question to you is, help me understand how judges are supposed to do that.
Yes, I think that, as I have said, I think that one way that this court can do that and should do that is to look at the analysis that the United States Supreme Court has undertaken in a number of cases posing exactly these questions, and determine if that court's analysis as to the scope of liberty is appropriate in the Kansas Constitution.
But how do we do that? Because the standards that, at least that I just read, have to do with changing social conditions, enlightened ideals, and the general march of progress. I guess what I'm asking really is, how is this anything other than just a blank check to judges to read the Constitution in whatever manner they choose to do so? What are the constraints on that?
Right. Well, Your Honor, I think that that's a judicial duty that the courts undertake all of the time in many, many contexts. And here, I think the proper way to begin would be to consider the nature of liberty and whether there are certain core values that must be recognized as part of liberty for it to be meaningful. And in the specific context of abortion, those values include, as the Casey Court recognized, matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy. And at the heart of liberty is the right to define one's own concept of existence. I think that these values expressed in the context of a specific question about the right to abortion do provide this court with strong and clear guidance as to how liberty should be defined. I think that Judge Atchison also made a very strong point that one of the core values of liberty has to be self-determination. And without self-determination, liberty becomes essentially a hollow promise.
Counsel, to piggyback on what Justice Stegall was just saying, I'll go back to the question I asked opposing counsel. The language in Section 1 says all men, says nothing about women. So how did we get from that plain language, all men, to women, to finding a right to an abortion?
I think that your observation about the fact that Section 1 refers only to men underscores the importance of this court's recognition that constitutions have to evolve to reflect changing social conditions. It is inconceivable in this day and age that women would be denied protection under the first section of the Bill of Rights simply by the fact that they are women and not men. And so I think that the process is, first, this court has recognized that Sections 1 and 2 provide enforceable rights. In deciding the scope of those rights, this court has looked primarily to the 14th Amendment, acknowledging that the scope of those rights must evolve to reflect, as Judge Atchison referred to, maturing societal values, as this court has talked about, the general march of progress. Then the next step is, if liberty is an enforceable value, does the right to abortion encompass those critical values, and therefore should it be recognized? And obviously we think that the answer to that is yes.
But once it's recognized, you would concede that the state has interests in how the self-determination is exercised on reproductive rights.
Yes, the state, as it does in any context in which it regulates in a manner that affects constitutional rights, has interests. I think the question that you may be getting at is what level of interest should the state have to assert in order to infringe on the constitutional right to abortion? If I- Am I jumping ahead?
As I mentioned with Professor McAllister, for whatever reason, I got kind of seduced by the Ohio decision, and this isn't a test as to whether you remember that 1992 or 3 or 4 opinion. But I was kind of seduced by its articulation of the state's interest in these matters versus the individual's interest, and how it kind of becomes a sliding scale. The concurring dissenting opinion in that case, though, looks at the undue burden standard and says, and it had just come out, and said, this is kind of goofy. I mean, it's kind of made up out of whole cloth, and it doesn't look like any kind of a standard that courts have used in the past in analyzing the competing interests that go with a constitutional right. And so that particular judge happened to suggest, well, maybe not a compelling, but it ought to be a heightened scrutiny kind of thing, but then all of a sudden you're in equal protection, and I don't know where that takes us. But I want to get at the undue burden standard and kind of the contours of whatever it is may be happening. You would agree that looking at this D&E ban requires a different level of review than maybe the informed consent interests that the state might have, or do you? It just seems to me when you're talking about which medical procedure gets used on a person, that is a more important discussion than what the patient has to read before procedure is done.
The answer to your question, unfortunately, is slightly complex, because I think until the court settles on the level of scrutiny, it's premature to get into the specifics of the statute. And we think that the appropriate level of scrutiny here is strict scrutiny.
But just as an initial thing, don't we have to talk about, let's assume we get past there is a right. Now we have to send this thing back to the district court so that you guys can fight about what it is. Don't we have to articulate more than just a yes or no? We have to kind of provide you the contours. That's why I'm getting at this question. So I'm kind of giving you, so how do we do that? How do we direct the district court to what guidelines and standards are we going to use for the district court so it can do that?
Right. And that, I think, really goes to the question of what level of scrutiny this court determines is appropriate in assessing restrictions on, obviously, what we hope will be the recognized right to abortion. And our view is that given the fundamental nature of the rights and the liberty interests that are implicated by the right to abortion, including privacy, autonomy, dignity, and bodily integrity, that this fundamental right should be reviewed under strict scrutiny.
So your position is strict scrutiny would be the standard that's applied. Do you think the state has any interest in the potential life of the fetus?
Yes, the state does have an interest in the potential life of the fetus.
And then if we recognize and take your position that strict scrutiny would apply, how is that potential then for life accommodated? I don't see how it is.
Right. So when this court has adopted and applied strict scrutiny in other contexts, it has repeated the test that the state's interests must be compelling and they must be narrowly tailored. Compelling interests are those of the highest order. And so as the state recognized, the Supreme Court of the United States has recognized the state's interest in the life of a viable fetus as a compelling interest. But interests that are less significant, for example, economic interests or significant matters of policy choice, do not rise to that level of compelling interest. And so in the context of restrictions on abortion, the state's ability to express its interest in potential life in ways that directly infringe on the right to abortion is more limited. That doesn't mean, however, that the court doesn't look at the rights asserted and make a case-by-case assessment of whether they are adequate and appropriately tailored. It does, however, put the burden on the state to show that they are compelling, which, given the nature of the right, is the appropriate standard. Now, we have argued alternatively that this case, that the act in this case, Senate Bill 95, is unconstitutional under the undue burden standard. And I'm happy to address that standard as well if you would like me to.
I want to get to the I want to apply strict scrutiny on a much less intrusive sort of level.
Yes.
And so let's just say informed consent, and I realize that could become intrusive, but just keep it at its basic level. How would you apply strict scrutiny to the state just wanting to make sure that the exercise of these reproductive rights was being done with informed consent?
Right. And so, following the decision in Roe versus Wade, the United States Supreme Court held that it's permissible for the state to require informed consent, as it does for any medical procedure. But where the state might cross the line is by putting its thumb on the scale to try and influence women directly not to have abortions and to favor childbirth over abortion. And so obviously you would have to look carefully at the contours of what the state was seeking to require to decide if it crossed that line. But in general, under strict scrutiny, the Supreme Court of the United States said that the state cannot assert that interest in a way that burdens the exercise of the right.
But now you're into undue burden, and I'm trying to figure out if there's a difference between that and strict scrutiny, especially on this. If we're going to recognize the state has an interest, then we got to play fair and make sure that the state can properly exercise its appropriate interest. And it seems to me that there's a continuing scale here, and the interest of the state gets greater and greater as viability gets closer and closer or crosses the line. And I'm just trying to figure out how strict scrutiny plays along a scale that is more intense or less intense depending on where you are in the process. You see what I'm saying?
Yes.
Okay.
Certainly strict scrutiny strongly affirms the right of women to obtain abortions prior to viability and puts significant restrictions or limitations on the state's ability to regulate prior to that time. But I think it's helpful at this point to compare strict scrutiny to the undue burden standard, if I might. So, starting with the idea that the reason that there is a right to abortion is that it encompasses and affects several core fundamental liberty interests that I've identified: dignity, autonomy, bodily integrity. The nature of the right doesn't change based on the state's asserted interests. And what the undue burden standard does is it builds in assumptions about both the nature of the rights that the state is going to assert in support of a burden and the ability of the restriction to further those rights. And that's where we think that the undue burden standard is inappropriate. The nature of the right doesn't change. And let me give you a hypothetical, if I could. So in this case, the state is not asserting potential life is not asserting a compelling interest in potential life. And yet under the undue burden standard, it's assumed that their interests get a certain amount of weight, and that's why they don't have to show a compelling interest. But what if the state were to enact a tax on abortion, $100 per abortion, and the revenue from that would go into the general fund? Well, there's no reason to put a thumb on the scale in favor of the state's asserted interest in that case. And so I think that illustrates the problem with the undue burden, is it puts a thumb on the scale in favor of the state's asserted interest before the state has explained what interest it's trying to further in the context of a specific restriction. Strict scrutiny, by contrast, would not give the state's interests that extra benefit of the doubt, and it would require the state in each instance in which it wants to infringe on the fundamental right to come in and explain both why its interest is compelling and why its restriction is narrowly tailored to further that interest.
Counsel, a moment ago you answered a question from my colleague, Justice Rosen, about the state's interest, whether the state has an interest in potential life, and you said it does. I think that's what you said.
Yes.
The basis for that answer was?
I should clarify that the state has a general interest in potential life. That doesn't really answer the question, though, of how it may express that interest when it attempts to do so in a manner that infringes on a woman's constitutional rights. So the Supreme Court of the United States has recognized this generalized interest in potential life as one that is legitimate for the state to hold, and that becomes compelling after viability.
Counsel, we've talked a lot about the substantive content of Section 1, and we've touched on the scope of Section 1. We've touched at least a little bit on, does it cover men only because it uses the word man, or does it cover men and women? And my question would be, in your view, does Section 1 include within its scope unborn children?
No, Your Honor, I don't believe that it does.
And what is the temporal moment, I guess you'd say, at which that scope attaches, at which Section 1 attaches?
I would say that the point of viability is when the state's asserted interest in the
Well, I understand
fetus.
when we talk in terms of strict scrutiny, compelling interests, et cetera, that's a wholly separate rubric. I'm asking very specifically about the scope of Section 1 of the Kansas Bill of Rights. There has to be a point in time in which it attaches. And I'm just asking you for your position. When does that right attach?
Yes, I believe under the analysis that this court has adopted in looking to the 14th Amendment, that this court should bring in the Supreme Court's analysis on that issue and say that those rights attach upon birth.
So, upon birth as opposed to viability. So that your position...
I think there's two different concepts, Your Honor. Right. One is, at what point do constitutional rights attach? Right. The second, though, which is distinct in some ways, is at what point the state has a compelling interest on its compelling interest.
And just so I understand, I think I understand, but your position is that based on United States Supreme Court precedent, the state's compelling interest attaches at viability, and the rights, whatever they might be within Section 1, attach at birth.
That's correct, and that is not reflective only of United States Supreme Court decisions, but of the numerous decisions made by other state Supreme Courts.
We've talked a little bit about the potential ripple effects or implications of whatever we might do here today. Kansas has passed a statute known as Alexa's Law, which allows the state to prosecute individuals for capital murder of an unborn child. And in fact, even recently, this court has upheld convictions under that law. I guess my question is, is that consistent? Does that make any sense? Could it be that the state could constitutionally prosecute somebody for capital murder of an unborn child who has no rights under Section 1?
Your Honor, I hate to speculate on how a case might come out where in the absence of concrete facts.
Sure.
But I believe in the context of the capital murder statute, there are a number of what would be considered aggravating factors that could lead a jury to conclude that the death penalty was appropriate.
I guess I'm just asking, how can we convict somebody of murder of an entity that has no inalienable rights, has no right to life? How can that be consistent? How can the state do that?
Well, Your Honor, I don't know if I can reconcile those two things because
Well, Counselor,
it's
our criminal laws are to protect society, that we don't want people running around killing people. And it's not to protect the right of the individual, is it? It's a societal protection. And so we don't want people killing other people regardless of what rights they have, which is the distinction. They don't have to possess constitutional rights to be a victim of a crime. So that would be the distinction, is that the murder statutes are a societal protection, that you can only act this way if you want to live in Kansas, regardless of the status of the victims. Wouldn't that be the difference?
yes, and thank you, Your Honor.
So the difference is that, as Justice Johnson said, you can't go around killing people, but some people have constitutional rights and other people don't.
Well, you're presuming that a fetus has constitutional rights.
Well, but
I
no,
believe in
that goes to the
question.
heart of my question. If the criminal statute says, colloquially, as Justice Johnson just referred to it, you can't go around killing people, but not all people have constitutional rights. I'm just asking if that's your position.
Your Honor, I can't really answer that question. I think that Justice Johnson has provided a good explanation. I think the heart of our issue is the rights of Kansas women. And those are the rights that we are
and I
asserting.
appreciate that. And I could conceive of a position, and I understand this is not the position you're taking, but I could conceive of a position where you might answer, or a hypothetical attorney might answer, that in fact the scope of Section 1 does extend to an unborn child. However, we also must consider the rights of the woman, and then we get into these various balancing tests. I mean, that's one way to approach the issue. That wasn't the way. That's not the approach you've taken, and so which gave rise to my Alexis Law question.
Not in the context of a woman's right to exercise her own liberty interests. Whether there might be hypothetical situations in which somebody could make a compelling case to this court, completely divorced from competing interests of the woman to her own bodily integrity and autonomy, perhaps. But I think that that's far afield from the much more concrete issue before this court, which is the burdens that SB 95, the concrete, real burdens that SB 95 imposes on women seeking abortions.
There is at least some reference in the state's briefs to a need to also define the word life in Section 1. So from your last answer, do you disagree with that we can decide this case without reaching that question?
I do. I think that the issue squarely before this court is whether Sections 1 and specifically the liberty interests identified in Section 1's inalienable right to liberty clause protect the right of women seeking abortions under the Kansas Constitution. I don't think that it's necessary for this court to look at that other language in order to answer that question. And certainly the United States Supreme Court has not felt the need to answer that specific question in developing the right to abortion under the 14th Amendment.
Let me throw another curve at you. With regard to the concurring opinion, what would be the downside for your client if we were to adopt Judge Atchison's belief that Section 1 is a standalone, different animal of its own, not tied to the 14th Amendment, and simply provides a right of self-determination that he opines includes the right to abortion in this case, but uncouples it from all that federal jurisprudence. What's the downside for your clients?
Your Honor, I think that Judge Atchison makes a compelling argument about the strength of self-determination and that it is a unique standalone right. Coming before this court, however, we think that that the practice of this court has not been to do the analysis that way, but rather to look at the 14th Amendment. And so I think there are two ways to get to the same result, which is that abortion is protected under the Kansas Constitution and that it should be afforded strict scrutiny. But the more typical path that this court has taken has been to look to the 14th Amendment. So I think that just based on the analysis that we have to work with, while Judge Atchison's arguments are well supported, they do depart from this court's usual course.
Counsel, opposing counsel has asked us to explain why this court has used the United States Supreme Court case law, its interpretation of the 14th Amendment and the language of liberty, and applied that almost wholesale to Section 1 and Section 2. Can you provide that explanation for us so we might have a head start?
Yes, I think as I mentioned earlier, I think that this court's practice of looking to Sections 1 and 2 simply reflect a recognition that the United States Supreme Court's decisions looking at due process and specifically at liberty, that their analysis of the scope of those rights and the basis for those rights is sound, and that they protect values that are also critical to the citizens of Kansas. And so it's not simply that you should do it because the United States Supreme Court has done it, but because the United States Supreme Court has done it well and has recognized important individual values, has recognized the evolution of the scope of liberties, has taken into account changing societal values. And so the Supreme Court has, if you will, done a lot of the hard work and thinking that goes into the correct result that this court should reach under Sections 1 and 2.
And you believe that that is all found in our case law, or it's just implied?
I think that it's more implied than found, but I think that the Lyman case actually is a pretty good example of this court looking carefully at the substantive due process analysis that the Supreme Court undertook in Lawrence and applying that to an equal protection argument brought under the federal and state constitution. And so at different points along the way, this court in Lyman could have rejected or criticized the analysis undertaken in Lawrence, but instead looked at it carefully and said, yes, we agree with this. We think that this is the right way to go. And that's essentially what we're asking for the court to do here.
That reliance on federal jurisprudence, though, only postdates the 14th Amendment, because prior to that time, this court had to decide those issues solely on the state constitution because there was no application of the federal constitutional rights to the states. So it's a post-statehood phenomenon from this court, post-14th Amendment development.
Right.
So the point is, we have a history of looking at our Constitution by itself.
Yes, both. But since approximately 1917 in the Wilson case, I think this court recognized that what was happening under the federal 14th Amendment was useful and instructive to this court in deciding cases of equal protection and due process under sections 1 and 2.
Outside of the Limon case, is there anything in our case law that says that we were deliberately doing what the Supreme Court had laid out because we agreed with their analysis, or are we just lazy in saying, we'll take that?
Your Honor, I think that there are some other examples, although perhaps not as many clear examples as we would hope. But I think in the Farley case, for example, this court did a careful analysis of federal law, but in that case acknowledged that this court could actually go beyond what the federal Constitution protected. And so I think there are examples where the court has really engaged on in looking at the analysis that the Supreme Court has undertaken critically, and in most cases where it has done that, agreed, in some cases deviated. But there are also a number of cases in which the only thing that this court has said is that sections 1 and 2 typically mirror the federal Constitution. That doesn't mean that that analysis should be rejected. It just means that in many cases it was either not necessary for the court to engage in that analysis, or it simply adopted that and moved on.
Well, Lawson, on other sections of the state constitution, discussed some of the rationale for being in lockstep with the federal Constitution. One of those has typically been for uniformity. So you have more uniform law throughout the country, that kind of thing. And that's where I think you got the quote from ebbing and flowing in the federal jurisprudence that was to negate that argument for lockstep interpretation, wasn't it?
Yes, and we think that actually the desire of this court that it has expressed for stability in constitutional protection actually favors application of strict scrutiny here, because as we've seen, the federal Constitution has gone from strict scrutiny to undue burden. We hope that it remains at least at undue burden as it has been expressed recently by the court in Whole Woman's Health, but stability would come, I think, from application of the strict scrutiny standard.
In applying undue burden, the Court of Appeals, what turned out to be the dissent, concluded that the ban on the D&E procedure is unconstitutional under federal law. It reached that conclusion, but withstands constitutional scrutiny in Kansas because it still allows a D&E so long as the doctor first ensures fetal demise. Do you agree with that conclusion?
I don't, for two reasons. One is that, first of all, that conclusion is premised on the decision that there would be no protection for abortion under the Kansas Constitution, which obviously we disagree with. But I'm sorry, I'm not sure I'm going to answer your question. Can you state it again?
Well, the Court of Appeals dissent said that Senate Bill 95 withstands scrutiny because it still allows for a D&E procedure so long as the doctor first ensures fetal demise. That was their conclusion. So
Right.
it survives constitutional scrutiny under the Kansas Constitution.
Right. And we strongly disagree with that for two reasons. One is that the bill that we're talking about here, Senate Bill 95, bans the most common and safest method of second trimester abortion. To say that it's not a ban because you can add something to it doesn't change the fact that it would be illegal for Dr. Hodes and Dr. Nauser to perform a D&E procedure, the safest and most common, as they are currently doing that. But perhaps even more importantly, the idea that the Court of Appeals dissent adopts that there are reasonable alternatives here that would alleviate the constitutional burdens is completely unsupported by the facts that have been found by the district court. And those facts include that the only way to accomplish a demise by digoxin is to use a spinal needle to inject the woman through her abdomen or through her vagina in order to accomplish demise, and that must happen 24 hours prior to the procedure, that it's painful, it can be emotionally difficult, and that it comes with increased risks of hospitalization, delivery outside of a health facility, and injection. So for the Court of Appeals dissent to argue that these are acceptable alternatives is really going much, much further than any court has ever gone, essentially conditioning the right to a second trimester abortion on the acceptance of an additional unnecessary and risky medical procedure. And in some cases, because this act takes effect whenever a physician wants to do a D&E procedure, which is around 15 weeks, and digoxin is not used until 18 weeks, as the district court correctly found, it would amount to experimentation on women. That cannot be the price that Kansas women have to pay in order to obtain a second trimester abortion.
Counsel, I had one last question. My understanding in response to Justice Biles' question on why your clients made a strategic decision to bring this suit only under the Kansas Constitution, and I recall your answer being generally that, well, there may be a point where we need to depart from the United States Constitution and the rights that it affords for abortion. And in that event, we want to have the Kansas Constitution as a fallback. Is that a fair characterization of what you said?
More or less, yes, I think.
Okay. So my question is, you're asking us to basically say that since 1917, this court has found the United States Constitution, United States Supreme Court interpretation to be correct or sound, and that should be applied to our interpretation of Section 1 and 2. So I'm kind of curious why for 100 years it sounds like you say that the United States Supreme Court has been correct and this court has been correct to follow them. But now that's not good enough and you want us to do something different under the Kansas Constitution.
I think there are two parts to that, to my response to that. First, we are asking for independent recognition of the right to abortion, and so I think that is a wholly distinct question, and it would, if I described it as a fallback, I think it would mean that there were co-equal rights under federal and state constitution, and that both would be available to protect the right of women seeking abortions.
And that would be used in the event that the United States Supreme Court reached a decision on abortion that you and your clients disagreed with, and you wanted to use the Kansas Constitution as the basis. Is that a fair statement?
Not completely, Your Honor, because we are asking for strict scrutiny here. We do think that the Kansas Constitution should provide additional scrutiny in this unique circumstance where we have a fundamental right that is not receiving strict scrutiny under the federal Constitution. I would also point out, though, that the state here is arguing that we lose under the federal Constitution. And so the mantra that we have federal rights that we can assert is not the answer according to the state. And we think that recognition of rights under the Kansas Constitution would give us additional claims and an ability to fully attempt to vindicate the rights that are at stake here.
Thank you. Do we have any further questions? Counsel, I just wanted to give you the same opportunity I gave opposing counsel. We've been spending a lot of your time asking you questions. Would you like a minute or two to wrap up, or do you believe you've completed your presentation?
If I could have just 1 minute, I would appreciate it. Thank you. So, in conclusion, the liberty and due process protections of Sections 1 and 2 of the Kansas Bill of Rights protect core values of personal autonomy and decision-making about issues that affect one's physical health, family life, and the decision of whether to bear a child. The right of Kansas women to terminate a pregnancy should be recognized and protected as a fundamental right. The Act violates this right by banning the most common method of second trimester abortion and by imposing extreme and unreasonable alternatives that would subject women to more complex and risky, and in some instances, experimental procedures. This is not the price that can be exacted on Kansas women seeking to exercise their right to second trimester abortion. The district court was therefore correct in issuing the temporary injunction against the act, and we respectfully ask that that ruling be affirmed. Thank you.
Thank you, counsel. You've reserved 10 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, I will try to touch on a few points that I think came up during my colleague's argument. One point I want to address is Justice Stiegel's question about life and the fact that Section 1 says life, liberty, and property. And in fact, the U.S. Supreme Court has addressed that question, and it did it in Roe versus Wade, because there was an argument that the unborn child was a person under the 14th Amendment, and the court had to say no to that argument before it went on to recognize the liberty interests of the woman. Otherwise, if the unborn are within the scope, then you have a very direct conflict between potential assertions of rights here. So I just wanted to clarify, as a matter of federal law, the Supreme Court did address that and had to reach the conclusion that a fetus was not a person until born.
Counsel, I'll just take that opportunity to ask you the same question I asked your opposing counsel. If an unborn child does not fit within the scope of Section 1 of the Kansas Bill of Rights, is it within the state's power to prosecute an individual for capital murder of an unborn child?
Well, I have to be careful answering that because I represent the state, and we would have to defend that statute if it were challenged.
I'm not asking you to, I'm not going to hold you to it, but as you stand here now.
Yes, I understand and I see the inconsistency. I mean, if you're going to say someone can be put to death for terminating the existence of a being, if you will, they might say, that has no rights under the Constitution, that would seem to implicate important questions.
If the unborn child is not, it is not folded into or is not within the scope of Section 1, what is it? Is it property?
The state...
Is it a person without constitutional rights? Do you have an opinion?
Well, I mean, the opinion of the state here, at least in this case, is that that's a question that needs to be considered in the context of Section 1. If Section 1 is to be given...
And so what is the state's position? You're asking us to consider that. What's the state's position?
Well, all I can't say the state has thought about that as a legal matter to assert, for example, that life begins at conception. I don't think we have a statute that says that, like Missouri does, for example. If the legislature had that, then I'd be able to say that is definitively the state's position, but I can't say that right now. But to your point about the consequences, Missouri did adopt a statute that said life begins at conception, and as I recall, that led the Missouri Supreme Court to say wrongful death claims arise for causing the death of any fetus, not just a viable fetus. So I do think there's a tension in saying Section 1 only protects liberty interests of certain people, but not life interests potentially of others. So I certainly acknowledge your struggle with that question. I would also...
Mr. McAllister.
Yes.
You do a lot of criminal law, as you've acknowledged a moment ago. We don't typically take up constitutional issues in criminal cases unless they've been raised by the parties. Isn't that right?
Correct.
And that particular question posed by my colleague has not come up yet, to your knowledge.
To my knowledge, not yet.
Thanks.
Yes. But I do understand his argument that if
Sure.
there's a potential inconsistency there.
Not holding you to it for your next case.
And you're right, I never know which statute I'll be defending next. So, as far as standard, I wanted to come back to some of Justice Biles' questions. I think there's a very good question in there as to why, if this is a substantive due process right, we would be looking to equal protection standards to define it. And strict scrutiny is definitely an equal protection standard. It is not anything under federal law that is used for substantive due process claims. In fact, under federal law, substantive due process claims have really, for the most part, except Roe for a time period, they have been treated as involving their own standards. In abortion, it's undue burden. In other contexts, the court looks for things like a deeply rooted tradition of this narrowly defined interest. So I think there's a very fair question why the court, if it were to go and say Section 1 recognizes a substantive due process right, why in the world the court would want to adopt an equal protection standard for evaluating that. And connected to that is, people throw around words, fundamental right, liberty interest. I mean, technically speaking, what the U.S. Supreme Court talks about is liberty interests for the most part, because they're tying to the word liberty in the 14th Amendment. And since the beginning of considering such claims, including Roe itself, that court has been explicit that no liberty interest is absolute. And I would posit that going to something like strict scrutiny gets one close to making it an absolute interest. Strict scrutiny, as the court is well aware, is not a standard that the state frequently meets. It's a high burden. In part, even when the state has compelling interest, there are almost always other ways a law might be tailored to try to address an interest, so cases often strike down state laws on the basis of failure to be narrowly tailored. So that would hold the state to an awfully high burden in an area where at least the U.S. Supreme Court has repeatedly recognized important and at times compelling state interests here.
Mr. McAllister,
go
I
ahead.
have a quick question. Having heard everything you just said and taking it into due consideration, if you assume with me for the moment that we are going to be talking about strict scrutiny, it sounded to me, based on your argument and your opening argument, that these concepts of compelling state interests, as we discussed it, and narrowly tailored or intention, because to the extent you say it's narrowly tailored because alternatives are left for a woman in the position of needing abortion in her second trimester, that undercuts the compelling nature of the state interest, does it not?
Well, no, I think the compelling interest is a societal judgment about the typical way of performing a D&E, and what I was trying to, so that's the compelling interest, but in the medical profession and the dignity of life, but the narrow tailoring is then not just saying the whole situation is banned, but saying you can still perform D&Es with alternatives that are out there. So it's more narrowly tailored than a ban. And I know we disagree on that proposition. My colleague says it's really a ban. I'm saying it's not a ban, it's a limitation on methods. But that, a ban truly is one thing that would be hard to argue is narrowly tailored, because there's almost always some other way, but I don't view that as what this law does. I also wanted to speak to the notion of evolving standards, evolving constitution. I mean, at some level, that may be true. I think there's certainly arguments here that we wouldn't understand the word men in Section 1 to mean literally only men today, but I do think it's a matter of judicial judgment. Because the risk is that if you just say, well, the Constitution changes with the times, then it's the judges who ultimately decide what do the times require. And I think first and foremost, it should be the representatives of the people, the legislature and the government. And that's the primary way, and a big difference between the state constitution and the federal constitution, is state constitutions do evolve, and they evolve by amendment. State constitutions, literally, most of them have been amended dozens, if not hundreds of times. Some have been completely rewritten. Some states say they have to be reviewed every certain number of years. The U.S. Constitution is a very static creature. very hard to amend. If you look at it, take out the Bill of Rights, came right out of the gate, 17 amendments in over 200 years. It is a very difficult thing to amend, but that is not true of state constitutions. We do it all the time. Virtually every election cycle, there are proposals on the ballot. I would also say, in looking at the text of Section 1, I did want to mention...
I'm not sure I get the point.
The point is that the evolution can occur very much through the political process. You know, I would say if you were going to make an argument that evolving standards should inform the Constitution, it may have more persuasiveness with respect to the federal Constitution, which is very hard to amend. I don't see it as having as much persuasiveness when the state constitutions are comparatively much easier.
Then does that mean that for a woman to be able to save her life by having an abortion, we have to wait for a constitutional amendment?
Well, we had this discussion earlier, and that is one option, or it could be a statute that would say that. It wouldn't have to be a constitutional amendment. But even if you were to say there is something in, and I guess what I'm really getting at bottom, Justice Bowles, if you were to say that there is something there, substantive, in Section 1, that this court should be cautious about exactly how much and what that something is, because we do have a way. You know, this court has often said, we're interpreting the people's constitution. Well, the people have a way, a fairly ready way, to alter and amend this constitution.
Well, I think our case law recognizes that, doesn't it?
It does.
You know, it talks about, you know, be careful. That this isn't just subject to judicial fiat, that we're looking at fairly fundamental kinds of things. And so...
Which is what?
Trying to draw the line, it still seems like reproductive rights is a pretty fundamental thing. I don't know what we make of it after that, but it seems pretty fundamental.
And if the court makes that determination under Section 1 that there is something to be protected, that does not, though, automatically lead to strict scrutiny should be the standard.
What are the choices?
For scrutiny?
Yeah, with this, I mean, obviously rational basis.
Rational basis, which is basically the baseline for, in general, for due process and equal protection claims, both. Strict scrutiny, as I said, is really an equal protection concept and is typically not invoked in a due process setting. Therefore, I wouldn't suggest intermediate scrutiny is really appropriate either. That's an equal protection notion. Undue burden, that's what the Supreme Court of the United States came up with, but that's unique to abortion. That's their own formulation.
Do you agree with undue burden that the first step is rational basis and then it's whatever? Then we analyze how much burden there is after that?
To a great extent, yes. I mean, the way I would view undue burden is basically the state has to have legitimate interests that are behind the regulation. And then I think there is a look at how much imposing those interests or regulating those interests in a particular situation interferes with the right to choose to terminate a pregnancy. I mean, it's very much a balancing, but I'm not sure it's really even a balancing of comparable things. It's a tricky test in many ways because it's not very precise. But I do think in an undue burden, basically if the state can show we have an interest in patient safety, we have an interest in the ethics of the medical profession, we have an interest in potential human life, which is an interest, as my colleague acknowledged, that exists from conception. It becomes stronger and stronger when we get past the point of viability, but it exists from the beginning. So the state can point to those, and if the law seems rationally to be about those things, then yes, then I think then it's on the plaintiffs to try to come forward under that test and show that nonetheless these regulations are a substantial obstacle.
Are those the only two choices we have?
No. I was going to suggest I think you have a world of choices, but I don't know. You know, I mean, this court in theory
I'm
could
just going
create
rational basis, undue burden. I'm not sure where I'd put that on the line, but undue burden. And then is there anything else above that?
Not in the state's view that would be has been articulated yet that would be even potentially appropriate here. I mean, certainly intermediate and strict scrutiny as equal protection concepts are not appropriate to this kind of setting. You know, and to your auditor's point, I mean, when you think about these things, the U.S. Supreme Court has been fairly, I would say, imprecise in the substantive due process context. So you take something like the Cruzan case where they wanted to terminate the life-sustaining measures of a person, and the court said state has a legitimate interest in the protection of human life, and it's reasonable, basically, to say, well, you've got to prove by clear and convincing evidence this person would have wanted her life terminated. Again, that's for that setting, but it's more of a reasonableness determination at bottom. Rational base.
Doesn't that statement acknowledge that there is a distinction between the state's interest in the potential for life or in life versus the independent entity's constitutional right to life under Section 1? You understand what I'm saying? Your opposing counsel said there's a distinction between enforcing the state's compelling interest and when a person's constitutional rights under Section 1 come into being. And I hear you acknowledging that.
Well, certainly didn't mean to. What I was trying to suggest is that in the substantive due process cases, at least the U.S. Supreme Court has tended to, if it even specifies, apply a much more flexible notion to whether the state's interests are sufficiently strong to regulate what the individual is asserting as a liberty interest. I still agree with Justice Stegall that there's an inconsistency, certainly very potentially, between the notion that you could put someone to death for causing the death of something or someone that has no constitutional right whatsoever, and then saying, but they have no rights in this setting either.
But that would come under the rubric of a cruel and unusual punishment, wouldn't it? Because, I mean, we criminalize the killing of non-human beings.
We criminalize, but we don't subject it to the death penalty.
Well, and that would then be an analysis under cruel and unusual. It wouldn't be an analysis of whether that non-human being had a right to life under Section 1.
Well, fair enough at one level, but then the cruel and unusual would certainly take into account the nature and the circumstances, what the crime was about. And so if it was a killing an animal versus killing a human, those kinds of things would be taken into account. You wouldn't necessarily define whether that fetus was a life, but it does seem to me, I understand Justice Stegall's point about the logic of it.
Speaking of logic and consistency, you had an interesting colloquy earlier about the Constitutional Convention and what was illustrated by the discussion there on happiness or unhappiness with the federal government and what the U.S. Supreme Court might do or had done. Would you say that on balance that those discussions reflect a concern with maximizing individual rights or governmental control?
I don't know if I could say one or the other predominates. They're both present in those convention debates. I mean, there was definitely, we want control of our state and our sovereignty, but there was also a fair amount of discussion about abolition and whether we comply with the federal fugitive slave laws and those sorts of things, which were about.
And that assertion of a right not to comply with that governmental regulation actually reveals some affection for individual rights, does it not?
It does, because the motivation was protecting the individuals. The power they were hoping to assert was governmental, sovereign, a way to resist efforts of the federal government. Yes.
Okay.
Thank you. Yes, but on individual rights, it's a very mixed bag. If you go back to the convention, obviously, and who they thought would have those individual rights.
But counsel, that question and your answer raises, in my mind, a pretty fundamental question that we are grappling with, courts have always grappled with, which is the relationship between rights and powers, right? And so my question is, even if you are correct, the state's position is correct, that there is no protected right at issue in the Kansas Constitution here, doesn't the legislature's act, isn't it still subject to judicial review under some, call it rational basis standard? Because doesn't the act of the legislature still, even if there is no right implicated, have to fall within a limited enumerated power?
Well, No, for us, we're police power at the state level. So the federal government
Okay,
has
so
to worry about
if we
enumerated
call
powers.
police power an unenumerated power, it
Which
still has to fall within a power that
Is
is
an excellent
recognized.
point, because that is actually present in some of this court's cases and some that we've cited in the briefs that do invoke sections 1 and 2. There is discussion at times about, well, is this even within the police power? And the suggestion is if it's arbitrary and capricious, irrational, then it's not even within the police power. So you could think of it as a power question. as
So
opposed
even
to-
if the state, in its most fundamental argument, is correct, the state is not escaping review of its acts under the proper scope of its powers.
Under this court's cases, there would presumably be some outer limit to the scope of the police power. Yes. But the starting point would be that the state has the power to do virtually anything that it uses in the interest of the health, safety, welfare, and morals of the people. But this court has suggested in cases there are outer limits to the scope of the police power. One other minor point I want to just very quickly say, the delegates to the Kansas Constitutional Convention would not have been unfamiliar with a due process clause. They did not choose to use one, but since 1787, in the beginning of the U.S. Constitution, there's been a due process clause in the Fifth Amendment. So that has been there all along. They were aware of that notion, and they did not include it in the Kansas Constitution. And I'd also like to say, just remind the court, of course, that 13 members of the Court of Appeals did not agree with Judge Atchison's more free-flowing self-determination discussion. And I would just reiterate, I think, in fact, much of his discussion is inconsistent with the history of Section 1. Again, that control of one's own person language that was objected to and taken out seems to me to be a lot like the self-determination that he's talking about. And so that one, I think the framers actually quite clearly rejected.
Counsel, I'd like to go back to something you said a minute ago, and I understood you to say that there is no due process language in the Kansas Constitution Bill of Rights. I think more accurately it is there is nothing in Section 1 or Section 2, because I think there is something on criminal due process in the Bill of Rights.
And there's also Section 18, which talks about due course of law. So
Right.
yes.
So my question is, can we make anything out of that? The fact that the framers did put due process in other sections of the Bill of Rights, but did not in Section 1.
Well, I think you can, because I do think the Fifth Amendment to the U.S. Constitution had been there for decades. They were aware of the concept, and they did not include it in a general sort of equal protection due process, that sort of provision. So, again, I think where they put it in, it suggested they were recognizing most likely procedural rights in the criminal context or in the context of having a remedy for tort claims and so forth. But they didn't put due process in there to recognize any kind of substantive right, would be my answer. And that, yes, you can draw something from the fact that it's present there, but not in Section 1 or Section 2.
On the
I
flip
haven't-
side, the U.S. Constitution doesn't include the Declaration of Independence language.
True.
That's
True.
there, and which indicates to me maybe a desire to add more than the framers had put into the U.S. Constitution.
And I think in the abstract that's possible, Justice Johnson, but again, going back to reading the actual convention debates, it's not at all clear that that's what they were really, agreed, the language is broad, but it's not clear what they intended.
If they had understood those natural rights of life, liberty, and property to include due process rights, then there would be no reason to duplicate that with something that patterned after the Fifth Amendment, would there?
No, but there's no way, I think, that they would have understood those sort of rights to include the kind of privacy notions that we're talking about. And when this court tied Sections 1 and 2 to the 14th Amendment in 1917, we were still 50 years away from the U.S. Supreme Court thinking about those kinds of interests. And I guess what I'd say to the court in closing, unless there are further questions, would remind the court that there are a lot of reasons, the text, the history, the precedents that we've talked about, not to recognize a right, or if the court does, a very limited right here, not least because the plaintiffs do have well-established federal law that says they can challenge these regulations under the undue burden standard. And they've certainly not indicated in the litigation that they think they lose that proposition, but that is something we would go back and litigate if we got there. But I would say if the court opens the door, to go back to Justice Biles' metaphor, if the court opens the door here, it should remember what Roe versus Wade has brought to the federal courts. And what Roe versus Wade has brought to the federal courts is 44 years of contentious litigation. It seems to be never ending, and now that would be basically invited into the state court system if there is a state constitutional right. And again, Kansans have a way to make sure their constitution evolves with their desires and with their culture and with their mores, and it's the amendment process. And I recognize there's judicial judgment here, but with all respect, this one might be a step too far. And so I would close just by paraphrasing slightly Justice White's dissent in Roe, where he said, as an exercise of raw judicial power, the court perhaps has authority to recognize a right to an abortion, but doing so would be an improvident and extravagant exercise of the power of judicial review. So the state would ask this court to reverse the district court and reverse the grant of the preliminary injunction, and then let us proceed with the remaining claims in the case.
Do we have any further questions of counsel? Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement